This is Amy Trimble, the guardian ad litem.
Okay. And I believe we have Mr. Bondurant. Am I saying that correctly? I'm not hearing you.
Pretty close. Yes, Your Honor. I apologize.
Okay. All right. So he is here as well. So this is a check-in to see where things are. We have a guardian ad litem order that was filed on December 5 of 23, 100% county pay. So Ms. Turnbull, any report, anything you can tell us at this point?
I have made contact with both parties. They are being compliant. Mr. Bondurant has engaged in a substance use evaluation, and that the process of collateralization is in process. I have notified both Chelsea and Tristan from this case and a separate case that they can proceed with that. Mr. Bondurant has agreed to do a domestic violence evaluation, and I have put him in contact with Olivia Lovely, so that should be moving forward. We do have some concern about the mental health evaluation. He has had a mental health evaluation with Cowlitz Family Health Center or Health Clinic. I have not received those records. Mr. Bondurant has a history of trauma that he wants to protect. I think he's had some experiences with that being put out into social media, and he wants to have some privacy around that, and he's concerned with those records being released that information is going to get out. And so I think to some extent his provider is trying to protect that. At the same time, I have not been able to receive it. Mr. Bondurant has signed an ROI. I've sent over an ROI and request for records, and I've received nothing. I think Mr. Bondurant does not want me to have the assessment. At the same time, I'm a little bit concerned without the assessment. I can't fully appreciate if the diagnosis and treatment are recommendations are, how they've been come to, so to speak, and if the provider is fully evaluating or adequately evaluating his history in light of some of the things that we're looking at here. So I don't know if Mr. Bondurant wants to speak to that, but I would like as much access as possible, but while also respecting his privacy. And we've been hung up a little bit on this issue.
Mr. Bondurant?
Yes, Your Honor.
Anything you'd like to say at this point?
I did reach out to the provider. It's less me and more the provider. I don't know the legal ramifications of these providers giving full disclosures. I think that the issue being is that we're not sure the specifics of what it is that they're asking for. I know that the day that I originally signed a release of information, I must have had 3 or 4 people there. I would assume one of them being an attorney, just to ensure that that release of information was going to be reflective to what the court's requiring, and making sure that nothing else is being put out there for anybody, and to make sure that it's being put in the right hands, I should say. And there is a lot of childhood stuff that I can't say is relevant or not relevant to this particular case, but there are things. There's been a history of some of my information finding its way onto social media platforms. This is something that was mentioned into my assessment. So I think that the psychologist believes that he's just protecting that some of that information. It's not that they're trying to prevent things like diagnosis being out there or continued treatments or any of that nature, but some of the more sensitive information, he's hesitant and not exactly sure exactly what it is that the courts are asking, and would like more specifics before providing that information. He'd rather provide less, if that's what's required, than sending off all of it and then not all of that needed to be out there, if that makes sense, Your Honor. So we're kind of just in a weird spot where I don't know exactly what to tell them and what they're comfortable with sending over or what the process there is. But I sent a message over to him saying, if this is going to be something that's going to hold up, if my information being leaked or, being out there that for people's eyes, it's worth the risk to me to get my kids back. So, I'm going on 6 months at this point almost. So, yeah, I don't know where to go from there.
Ms. McLean?
So this is the first time I'm hearing a lot of this information. I am a little bit blind because I haven't had an opportunity to speak to my client about these issues. Last time we were before Your Honor, you actually had reserved in the temporary parenting plan for additional feedback from the guardian ad litem today as to whether or not there were additional evaluations and treatment that was going to be necessary or required of Mr. Bondurant. At the time, it was disclosed that he had an evaluation scheduled with Mr. Delagrange at Core Health. This is the first time I'm hearing about him now participating in an evaluation with Cowlitz Family Health Center. So I don't know who that provider is. I can't tell the court if my client has been allowed to provide collateralized information to Cowlitz Family Health Center, but I am aware that she had reached out to Mr. DeLagrange some time ago through Core Health. The allegations as far as information going out on social media, I'm not aware of my client having done that in the past or doing that currently. Obviously, information that comes about through a court action should not be disclosed through social media. I think that that should be across the board as far as information for both parties, that anything that's happening in this court action should not be disclosed on social media. We had originally asked the court at the time of our motion that the court require Mr. Bondurant to participate in a psychological evaluation with parental risk components. In my initial discussion with Ms. Turnbull and the information that I had forwarded to her, I did outline at least my understanding through my client of Mr. Bondurant's mental health history and the concerns that I was not aware of the qualifications or credentials of Mr. DeLagrange at Core Health and whether or not he was qualified to perform a psychological evaluation with parental risk components. So at this juncture, I don't know the level of the evaluation or the collateralization or who the provider potentially is at Cowlitz Family Health Center. And I don't know the qualifications of Mr. DeLagrange. So I guess I need some more input as it relates to Ms. Turnbull and the court on what we're going to do with reference to whether or not there needs to be a psychological evaluation as we had requested. This is the first that I'm hearing that Mr. Bondurant had agreed to participate in a domestic violence evaluation as well as a substance abuse evaluation. Again, those were evaluations that we had requested. And if you take a look at page 3 of the temporary parenting plan that was entered on December 5th of 2023, you reserved that for input from the guardian ad litem regarding the needed evaluations. So I guess I'm hearing from Ms. Turnbull that she does believe it is appropriate for him to participate in a domestic violence evaluation as well as a substance abuse evaluation. Again, this is the first I'm hearing of this, so I would need to know who those providers are so I can appropriately instruct my client to provide collateralized information because she does have information relative to those issues and concerns. So I guess at this point, we would ask that the court to order that he is to participate in those evaluations. Again, I'm a little flat-footed as it relates to this mental health evaluation or psychological evaluation and potentially whom that provider is. But I would agree that information from those evaluations and whatnot should not be disclosed on social media or outside the purview of this court hearing. And that should apply to both parties.
Turnbull, at this point, what evaluations are you recommending?
The substance abuse evaluation, the domestic violence evaluation, and minimally a mental health evaluation. I'd like to see what he's already completed.
Okay.
And then, potentially an additional mental health evaluation. I don't know the credentials of Mr. DeLagrange and what the extent of the mental health evaluation that's been done because I haven't seen it. So I'd like to reserve and, potentially have a mental health evaluation by a PhD level provider, depending on what's already been done.
So going to the going to the records and getting them disclosed. At this point, if you sign the release of information, obviously they want to know, make sure it's knowing. That's the only thing I can think of, but you signed the release of information. I expect the information to be provided. That's the whole point of having a guardian ad litem, is to be able to review that and say whether or not make a recommendation. I agree that there needs to be an order. Basically, anything involved in this action shall not be disclosed beyond the guardian ad litem, the parties, any attorneys that are involved, and the court. But that's as far as it should go. It should not be disclosed to any other third party or on social media of any nature. And so, Ms. McLean, can you draft and put together and basically an order of that nature so it's clear?
I can. And would the court also include providers? Because I'm assuming in particularly if there's a dual diagnosis, that there would need to be a sharing of information between providers as well.
Yes, that would be appropriate. And then I do want to have the substance abuse evaluation. It sounds like that's being done. Domestic violence evaluation, at least a mental health evaluation at this point by someone that's approved by Ms. Turnbull. So it may be that there needs to be an additional, I don't know his credentials either, but those credentials should be provided to the guardian ad litem and to Ms. McLean. So they're aware of what that is.
Your Honor, may I speak? I'm sorry.
Go ahead.
One thing I do remember when it was originally suggested that I was going to need a mental health evaluation, I do recall credentials being mentioned, and I recall it being a master level education or higher, and that is what I seeked out. So, and that was the only person in that particular office that had that level of credentials to be able to accommodate that.
Okay. And it may be very well, you may have done exactly what you needed to do. I just need it verified by Ms. Turnbull. That's all.
Okay.
And am I correct that I heard that Ms. Lovely is doing the domestic violence evaluation?
That's our hope. Mr. Bondurant had reached out to her without a response. And so I have emailed and hopefully connected them so that will happen.
And was there a recommendation on the substance abuse provider?
No, he sought that out on his own.
And do we know who that, can you disclose who that is?
That was done at the Cowlitz Family Health Clinic or Family Health Center.
The outpatient services. And
so at this point, I think I've given direction. I think we're getting
okay.
off into other conversations that can occur offline. Thank
okay.
you.
Presentation.
What's that?
Presentation date.
So we can set it out 2 weeks.
Okay, thank you.
Thank you, Your Honor.
Thank you.
All right, be just a moment. I do want to take.
Madam Attorney, I'm Carly Bliss, appearing on behalf of Mr. Zandy and our client, Lindsay, now known as Rodman.
All right, Mr. Beam is present here in the courtroom, just so you're aware.
Okay.
Yes, we have Mr. Lawrence present. This is a guardian ad litem order that was entered on November 17, 23. The pay was 50/50 of $3,300. And so, Mr. Lawrence, can you give me an update as to where things are at this point?
Yes, Your Honor. Both of the parties have paid. I met with both of the parties. I am currently in the background check phase. I'm waiting for CPS documents and review of the history on Mr. Beam's blow and go. And I understand that Ms. Maeda has some information for me, but we haven't connected yet. So that's the status at this point. I anticipate I should have my report done within the next 30 days.
Okay. All right, Ms. Bliss, anything you wanted to add?
That covers the majority of what Mr. Zandy had relayed to me what was going to occur today. It was his request that we set essentially this review hearing over. Obviously, if Mr. Lawrence's report's not going to be completed for roughly 30 days, maybe 45 days out, to allow the parties the opportunity to review that, Mr. Zandig to be able to speak with our client regarding that and bring any other issues back before the court at that point. Just as an aside, the parties do currently have a mandatory settlement conference set in the coming weeks. It's anticipated that that's going to be stricken given the status of Mr. Lawrence's report. I do believe that there's an agreed order circulating amongst the parties, at least at this point. So I did just want to put on the record that it's the intention, at least of Mr. Zandig and our client, to strike that that mandatory settlement conference, pending Mr. Lawrence's report.
Okay, sir, if you can pull that mic right in front of you, you just turn it. There you go. I didn't know it was glued down.
Yeah, it's pretty solid.
Okay. So anything you wanted to say at this point?
I received an email from, I believe it was one of Mr. Zandy's assistants this morning, about 8:30, with the document for the agreement to strike the MSC on the 22nd. But I was only in agreement if Miss Maida was willing to return to the original parenting plan, which had been discussed previously. And as of right now, the email that I received before I came in this courtroom, that they are not in agreement. So I do not want that MSC to be stricken on the 22nd.
Okay. All right. Well, if there's not an agreement, then it'll remain on. Ms. Bliss, that makes you aware of that. Okay. That said, anything in regard to the guardian ad litem, that's what we're really about here. Anything else at this point?
Just want my kids back, Your Honor. I've jumped through every hoop and I continue to do it.
We're not here about that part. Anything in regard to contact with the guardian ad litem or anything that you need to, I don't know if you're doing any evaluations or anything like that.
I have my weekly domestic violence and SUD treatments that I've been doing, that I've been keeping in compliance with and supplying Mr. Zandy with.
Okay. Are you providing that to Mr. Lawrence as well?
He has not been in contact as far as I know with my either one of my counselors, my SUD or my domestic violence. Okay.
So you should make contact with Mr. Lawrence just to get that information and documentation to him as well.
Absolutely.
Okay. So anything else as it relates to the guardian ad litem?
That's it.
And I don't mean to cut you off in regard to what you're ultimately wanting, but we have a number of cases, so we just need to stay focused. Okay. So with that, I don't know of anything else today in relation to the guardian ad litem. If not, then anything else, Ms. Bliss, that you wanted?
Your Honor, I would just ask that we set this final GAL report hearing over so that there's still some traction. My proposal, and Mr. Lawrence can give me a better estimate, but if he's thinking 30 days, maybe February 20 coming back before the court.
Okay. All right, sir, does that work for you?
February 20th?
Yeah.
Absolutely.
Okay. So we'll go ahead and have a final review for guardian ad litem set to February 20.
Brett Bender present, Your Honor.
And that will be at 9 a.m.
Thank you.
And Mr. West is on as well.
Okay. And do we have Julie Brenning?
I don't believe so. And we have heard that she didn't plan on coming today, but that's just what we've heard. So
okay. Do you have, I understand this is on for finalization. So do we have agreed documents or?
This is unusual, Your Honor, because this is it's about 15 to 17 years, I can't remember anymore, between date of separation and the divorce or the divorce decree being submitted. It's a stipulated agreement. It got filed about a month ago, and then together with all the necessary documents for judicial signature. And then we got a notice that the judge, whoever heard it, I can't remember who, wanted to have a hearing. I suspect it's because of the delay and because it was an agreed order, to prevent any sort of fraud or anything like that. But the orders have been entered. They should be in the file, meaning they've been submitted. They should be in the file. I didn't get them back. So here we are. And I'm not really sure what the court's intent was.
Well, it looks like
and by the way, Ms. Brennan was served with the notice of the hearing. And again, we've heard that she just wasn't going to appear. It's not a complicated divorce either, Your Honor. It's very simple.
Well, the problem is, I don't have any final divorce papers to sign that are agreed and it looks like the prior one, order denying the motion or petition. So what papers that were submitted appear to be lined out and filed.
Your Honor, I don't know why it was denied. That's the trouble. And because everything was signed off on, both parties signed. It's a very simple divorce. And then I got the order of denial, not dismissal. And I never got the originals back. And this is difficult after this many years. I mean, they share a daughter. They have potential contact, but that's why I was a little bit frustrated, to be honest. But I can understand considering the length of time in between, but I have never received any kind of notice about why it was denied.
Well, the only thing that I can see is that only one party signed the final papers.
No, I both parties signed her. I don't know what to say, but I mean.
Oh, I'm just trying to go through this to try to figure out why.
Yeah.
So I have final divorce, legal separation, and at least on, oh, I see, I don't know, maybe if they didn't see this, the signatures, one is on the line, the other one was done below, and then there's an arrow over. I'm wondering if that's what wasn't seen, at least on the findings and conclusions about a marriage. I don't have both signatures. I don't know.
Oh God. I'm not sure why, Your Honor, because they both signed. And I'm not really sure what to do at this point. Track her down again, I suppose, and redo all of this, but I wouldn't have submitted it without two signatures on it. And so I'm not sure.
Well, the one which is the findings and conclusions appear that they might have two signatures, and one was done at the wrong place, and so there's an arrow. And then the final divorce order, there's a written signature that I have no idea whose signature that is. And then Mike West handwritten, but there's no signature on the right side. So that's what I'm looking at. That's my guess as to why it was denied. So at this point, the only thing I can come up with is that, yes, you'll have to track her down and get signatures.
Oh, that's great. All right. Because they both signed. I'll figure this thing out. Next time I'm up there, I'll take the file out and look. I'm not doubting you, Your Honor, believe me at all. It's just frustrating.
Yeah. Yeah. Unfortunately, they didn't. Sometimes the judicial officer will put on why they deny it. And so I'm doing some guessing here, but
Okay.
that's what I can see. Okay.
All right. Thank you, Your Honor.
All right. Thank
Good
you.
morning, Your Honor.
Yeah, bye.
Good morning.
Michael Trotter, representing Susan Weaver.
Okay. Do we have Charles Weaver or anyone on his behalf present? Okay. So I have great concerns in regard to the competency of Mr. Weaver at this point, based on what's been put before the court. I don't quite have enough at this point to have a guardianship filed that I'm aware of. So I'm going to, I've reviewed your documents and your files and that. And so I'll go through the list of those things. But what I'm going to do is I'm going to appoint Jennifer Schaefer, which is our in-house guardian ad litem, as a litigation guardian ad litem, to make an investigation as to whether he's competent, not a full determination of competency, but at least enough to know whether a guardianship needs to get filed.
Okay.
So with that, I'm going to go through your requests. In regard to the request to sell the family home, I'm going to reserve on that until I have more information as to the status of the respondent. Use of property in possession, the court will grant that, but nothing is to be sold, disposed of, moved, or in any way as I say, disposed of without court order.
Okay.
In regard to the vehicle, same thing. I'm going to reserve until I know the status of the respondent. Attorney's fees, again, reserved. And then, as I said, I'm going to have Jennifer Schaefer act as a litigation guardian ad litem to make that investigation. Until that is determined, parties are restrained from no assets are to be sold, moved, or disposed of by petitioner or anyone on her behalf, or the respondent for that matter. Parties, of course, is not implying that would happen, but just to protect things until we know the maintain status quo until there's a determination of things.
Okay, thank you, Your Honor.
And so that's where we're at. If you could prepare an order to that effect.
Okay.
And then just go ahead and get that to me for signature, just noting that he was not present.
Yes, Your Honor.
And then depending on, Ms. Schaefer, are you on there?
I am here, Your Honor.
So I'm not sure what your load is at this point. And I want to make sure you understand, if you read the file, you're going to understand what my concern is.
Okay.
And I just need to, he's in a nursing home in Vancouver. Is that where he is?
Mm-hmm.
Okay. Yeah, in Vancouver, he being the respondent. And I just need to, based on what was written up, I have great concerns that he may not be competent and a guardianship needs to be filed.
Okay.
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 All right.
Thank
All
you.
right. So with that, let's go ahead. How long, Ms. Schaefer, do you think that would take? Couple
Can
weeks?
I have like 3 to 4 weeks?
Okay.
Okay.
That work?
Yeah.
Mr. Trotter? Okay.
Monday,
Sorry,
Wednesday.
I'm just consulting real quick. Okay. Ms. Weaver has just wanted to make a statement that he is in, we can talk about it offline, but there's some things that may make him unavailable at times, such as his treatment. And so.
Yeah, if you could go ahead and can you go ahead? Well, she can get it from the file. Ms. Schaefer can get contact information from the file. The petitioner would be able to, she can reach out to Ms. Schaefer, or Ms. Schaefer will reach out to her. Okay.
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 Thank you, Your Honor.
All right.
Thank you.
If you want a presentation date, we can
Yes.
set it out a couple of weeks for that purpose.
Yes, Your Honor, that'd be fine.
So I'm going to give 2 dates. One is we're going to set a presentation date of January 23 at 9 a.m. Actually, I don't need a presentation date. Just send one to me to my attention. I can get that order signed. And I apologize, counsel. I need just a quick break and then we will get going.
Okay, no problem, Your Honor.
All right, so it looks like we have the respondent and looks like the petitioner is present, Ms. Petrie and Ms. Bliss. So with that, counsel, go ahead.
Thank you, Your Honor. Your Honor, this is our motion for temporary orders under the CIR. As to the personal property from the house, that can be stricken from our motion as we have resolved that issue. So the issues before the court today is we're requesting a temporary finding that a CIR existed and to make temporary orders accordingly so that discovery can be conducted and so that we can stabilize these parties through the pendency of this action. We are also seeking confirmation of vehicle possession, standard restraining orders, and standard restraining orders regarding disposing and using of property insurance. We are also requesting attorney's fees of $4,000, and I will dive into that in a second. The pleadings submitted along with the evidence supports the finding being requested. And the reason I'm asking for this finding, Your Honor, is that in my reading of relevant case law, there arose a question of subject matter jurisdiction can the court, just by simply filing a petition for a committed intimate relationship, does that open the door to discovery, or does there need to be a temporary finding of the existence of the CIR, some judicial affirmation before the court can actually take subject matter jurisdiction and issue standard restraining orders and enforce discovery requests? So that's why we filed this motion, to try to get that ruling, on a temporary basis, a designation that based on the initiating pleadings, a committed intimate relationship did in fact exist. It's kind of like a motion for summary judgment, I think, but not quite rising to that level. But we are asking for a temporary finding so that he is subject to discovery requests and temporary orders. Oh, and with regard to the attorney's fees, that is primarily because it's going to take us quite a bit of work to get things back on track, given the fact that respondent has already disposed of or removed my client from a number of accounts and insurance, which should not have been done had this finding, and would not have been done had this finding been made at the beginning.
Ms. Bliss?
And Your Honor, based on my experience, I don't think the court has to make a determination as to whether or not a committed intimate relationship occurred, at least at this point. My client, by filing a response and by participating in this action, acknowledges that the court has the jurisdiction over him to make a determination ultimately. However, in my experience in this county, the court typically reserves that finding for an evidentiary hearing or a trial. That is what we're asking the court to do today. I think by making a determination this early in litigation is going to essentially set the course for the entire case. And I don't think that that's proper. And I don't think the court has sufficient evidence before you. Granted, both parties have provided some responsive materials. I don't think you have the whole picture, and you don't have sufficient evidence from both parties, from witnesses and the like, that you would receive at a final determination hearing in this matter. So I'm asking the court to not make that finding, at least at this point. My client acknowledges that this matter has been filed, is agreeing to participate because he believes that the court will ultimately find that a committed intimate relationship did not exist. So there is not going to be any issues, at least from my position, as to issues with discovery and the like. As it relates to the request for property, I agree that I believe that the possessions have been exchanged between the parties. I do believe that there's still a request from Ms. Krakenberg as to the forerunner. I asked court to reserve on that. There was some discussion from both parties as to use of the vehicle. My client believes that's a separate property. I think the issue of that vehicle, by Ms. Krakenberg's own word, is a toy vehicle. I don't think that it's necessary to make a determination, at least at this point. So I am asking you to reserve on that. I would agree with the remainder of the property and the debts as allocated by Ms. Petrie in her motion. As it relates to attorney's fees, and I believe my client put in his declaration, and I'm more than happy to provide additional briefing to the court. I don't believe that by statute and by case law, the court can order attorney's fees in committed intimate relationship hearings. The determination in the statute as it relates to spousal support, or not spousal support, excuse me, attorney's fees is restricted only to marriages. And I do believe that there's sufficient case law to support that position. The legislature has not created a statute that indicates that attorney's fees are warranted in committed intimate relationship hearings. And I do have specific case law that I can cite to that echoes that position, that attorney's fees are not appropriate in committed intimate relationship hearings. If the court does want additional briefing on that issue, I'd be more than happy to provide, and I would just ask the court to reserve on that determination today.
Ms. Petrie?
Thank you, Your Honor. With regard to the case law and everything, especially with regard to attorney's fees, I think that's the whole purpose of having a temporary finding. I mean, in a regular traditional marriage or divorce case, we would ask for a temporary finding of who's going to be the primary parent. It's the same kind of thing. We need to make sure that the status of the parties is preserved by a temporary finding that a committed intimate relationship exists. And we did, in fact, satisfy all the requirements as set forth in the statute defining what a CIR is. Yes, the court can and will dive into the evidence and dive deeper in the final when it comes to final orders and trial. But in the meantime, my client needs to know that Mr. Mako is not going to be disposing of property or encumbering property that she might have an interest in. So we need to make sure that that standard restraining order gets issued and is applicable towards him. And I believe a designation on a temporary basis that a CIR existed will assist in making that possible.
So in regard to the idea of whether a committed intimate relationship exists or not does require an evidentiary hearing. And at this point, by the petition being filed, the response being made, and that the submission to jurisdiction of this court to make that evidentiary determination, the court does not find that a temporary committed intimate relationship decision has to be made. I've not heard that. So if there's something that I've missed or not, but I would agree with what has been indicated by Ms. Bliss. I think if they were objecting and as far as the court having jurisdiction over there, it might be something different. So at this point, the court accepts jurisdiction to get to that point of an evidentiary hearing, but the court would agree that doesn't feel comfortable at this point making such a decision based on such limited information, but certainly with the agreement that the court does have jurisdiction by the respondent, that is sufficient to move forward for purposes of discovery and for those purposes of moving toward that evidentiary hearing.
And Your Honor, when can we set that evidentiary hearing? And I'm not sure what Cowlitz's rules are with regard to the proper procedure for setting an evidentiary hearing versus a trial.
Well, trial is essentially just that. So I would go through the trial process.
Okay.
And then in regard to the Toyota 4Runner, and based on what the court had reviewed, that it looks like it was kind of the fun toy as indicated. So it will remain at the current location. I don't know where it's currently at, but that's where it's going to remain. And I'm not going to make any final decision as to who will get it. But at least for now, that's where it will remain. This is a temporary order, and the court is not dividing property. So I want to make sure that's clear. Sounds like the use of property has been agreed, so that's granted. Parties not moved, take, hide, damage, borrow, etc. That's granted. Each will be responsible for their own future debts. Sounds like that's agreed, so that's granted. Neither change insurance, etc. That's granted. Medical insurance to be paid by respondent. He agreed with that, so that's granted. In regard to the attorney's fees, that's an interesting issue that I haven't looked at in particular, but I believe it's something that I cannot grant in a CIR. That's my belief. But Ms. Petrie, if you have something different that you can show me, I can look at it. But at this point, I'm just going to reserve on that issue. You can note it back up if you like. I'm not denying it, but I'm not granting it. But I think that's something that can be looked at further down the line.
Okay.
And then sounds like personal items, like I say, have been agreed upon.
Yes.
Okay. All right. Anything else?
Entry?
Ms. Petrie, do you think we need a presentation date? I mean, I think she was pretty clear, and you and I work fairly well together. I don't.
We do. I don't think we need an entry date, but I do need the parenting plan from you, Ms. Bliss.
Oh, yes. So we've got some other issues. I would say that if we can't come to an agreement, we can just note it on.
Okay.
Yeah, that's fine.
Sounds good.
Thank you, Judge.
Thank you, Your Honor.
All right. Thank you.